Hello and welcome. My name is Ilda and I'm a partner in the Immigration Department at Kingsley Napley. Given that from the 1st of January 2021, British citizens travelling into Europe will be deemed as third country nationals, UK law firms who regularly send British lawyers to provide advice to their clients in Europe will first need to check whether work permission is required in advance of their travels. This is because every country in Europe have their own immigration rules. Equally, they should be checking whether there's any requirement to register with the local law society. To that end, I'm delighted to say that I have with me today two colleagues, Gunther Mävers, a very established and esteemed lawyer from Germany, Cologne, with a boutique law firm, and my colleague Iain Miller, a partner in our regulatory department. Iain will be answering some questions from a regulatory perspective, and my colleague Gunther will be covering some issues relating from a German immigration law perspective. I first turn to my colleague Iain. Iain, what is the regulatory position for UK solicitors wishing to fly in and fly out of Germany post 1 January 2021?
Thanks, Ilda. Well, the first point is that at the end of the transitional provisions on the 31st of December 2020, the free movement of legal professionals within the EU or UK legal professionals will come to an end because they can no longer take advantage of the European directives relating to cross-border practice by lawyers. In relation to Germany, to provide some context, Germany has the largest legal market of EU member states and indeed the largest economy. It's also the EU country with the highest number of UK lawyers operating there, including those on a fly-in, fly-out basis. There's no provision in law either permitting or prohibiting practice. So come the 1st of January, UK lawyers advising in Germany in respect of UK and or international law on a fly-in, fly-out basis will be doing so in a legal vacuum. However, in practice, we know that US lawyers, which is obviously also a third country as far as the EU is concerned, have been practicing and providing legal services in Germany on a fly-in, fly-out basis for quite some time. And as far as we're aware, no enforcement action has been taken in relation to that. That said, the regulatory framework in Germany is quite complex, and the definition of reserved legal activities, i.e. those that are regulated, is extensive and wide-ranging. On that basis, some predict that UK lawyers operating there on a fly-in, fly-out basis will not be permitted to do so.
Thank you, Iain. Are there any conditions or restrictions attached to the scope of permitted practice?
As I've said, the position in Germany for UK lawyers and fly-in, fly-out is not straightforward because of the legal vacuum. However, what is clear is that UK lawyers will not be able to advise in Germany on EU law on a fly-in, fly-out basis. However, UK lawyers will be able to represent clients in arbitration, conciliation or mediation in Germany on a fly-in, fly-out basis, as this is covered by the Civil Procedure Code as opposed to the EU directive.
Thank you. Will legal protected privilege apply?
The concept of legal professional privilege as such does not exist in Germany. The relationship between lawyers and their clients is instead protected by a number of professional confidentiality regulations. In the absence of the consent of their client or a mandatory legal requirement of disclosure, lawyers are prohibited from disclosing any confidential information or documents obtained in the course of their professional activities.
Thank you, Iain. I now turn to Gunther. Gunther, do you have any top tips for UK law firms that need to send their lawyers, UK lawyers, into Germany after the transition period ends?
Yes, absolutely. Firstly, thank you very much for the invite to speak here and to discuss those issues with you. And thank you also, Iain, for sharing the regulatory background, which is really important to know. With regard to the hot tips as of the 1st of January next year, I would say as per today, it's not really yet clear how the system will be functioning. But as far as I understand, there's hope that the British nationals will at least have, for a temporary period of time, a privileged status. and as such will be entitled to come into Germany and all the other Schengen countries under visa waiver-free status, so they wouldn't need a visa, and could even exercise some activities that are not categorized as employment. But as long as there's no deal in place between the EU and Germany, and as long as the national legislation in Germany is not reflecting that, there won't be any hot tips, because in absence of any such regulations, the principle that with no residence permit work shall not be permitted would prevail, and in principle that would strike out any activity that is considered actual employment, regardless of whether it's just for a minute or a couple of days.
Thank you, thank you. So assuming then, let's say just for a moment, because that's not uncommon, where you would have a British lawyer just literally going to be flying into Germany to visit their client, not really give any kind of advice. It's more a case of catching up with the client. And I'm assuming that will be permitted because there's no form of productive work. What is the maximum number of days that they could then spend in Germany?
Yeah, you're absolutely right by pointing out that just to meet a client or even to participate in meetings where a couple of issues are discussed but no real work is carried out, or conducting negotiations would be allowed. And that all for a period of up to 90 days within any 180 days, which is the Schengen allowance, I call it. And if you manage to fall under those exceptions from the rule where a work permit is not required, that would of course be possible. But it's a gray area and a thin dividing line between those activities and actually performing services.
Thank you. So I suppose, Gunther, this then follows on because, you know, we have lawyers that would no doubt be flying in to see and visit a client and no form of work. But then we're going to have the flip side of it, where you are going to have the British lawyer flying in to go and see their client in Germany, on this example, to give chargeable advice. It will be the advice under UK law. So if I've understood you right, I know it's complex from what you've said, but would that then, even if it's for one day or a few days, am I right in saying that that effectively would require work permission, or it wouldn't fall under perhaps one of the exemptions?
Firstly, if the people would, if the person in Sharjah would not practice German law, you wouldn't need a license to practice law in Germany. And nevertheless, to give advice on foreign law would be considered employment in the meaning of the German laws, and as such would in principle require a work permit. I mean, we know that in theory this is clear, but in practice, as Iain rightly also pointed out, enforcement is not such a big issue. And for instance, all the American lawyers that are flying into Germany on a day-to-day basis, overviewing due diligence processes, negotiating deals, they can fall under the exemption of conducting a deal. But if it's beyond that, if it's only working on behalf of the law firm and you charge for that, which is a good test question, do you charge for what you have done over here? Then it's likely to be work. Then you would require a residence permit, which many wouldn't ask for. They would just do it, like I have always been doing when I was in London, to see you and Nick to chat over something, and then the conversation may turn into actual business talk. And at the end of our talk, you may even say, "Oh, Gunther, that was very helpful. Please send us an invoice." You know, so it's quickly turning from what is normal and permitted to what is actually not permitted. And the hot tip would be here to prep the clients or the lawyers that they are aware of the issue, not to give the wrong answers when being put questions at the border controls we will unfortunately be having in the nearby future, and to know the distinction between what is allowed and what is not allowed. And if they then cross the line a little bit, that's still fine when they know that it's not so seriously when it comes to enforcement. But if it comes to longer activities, such as fly in on a weekly basis, every Monday to Friday, you would then probably be better off by applying for a long-term residence permit.
Thank you. That's really helpful. So then I suppose the last question has to be, if you do need to get the work permit, what kind of timelines are we expecting to secure the work permit, and presumably it's
Yeah.
something you have to get in advance of travel.
Yes, in normal circumstances, and that is, of course, if there wouldn't be a pandemic, the processing times are relatively good. In particular, with a view to the German embassy located in London, the folks working there are doing a fantastic job. And I have seen them processing permits within a day or a couple of days. Sometimes it took them a week, so it's relatively quick. But you just can't jump on a plane or on a train like you did in the past to Brussels or to Frankfurt, Munich. You would have to take those steps in advance. Meetings can be booked online. Of course, sometimes a physical presence is required to take some biometric data from your fingers, from your eyes. So representation is unfortunately not possible. And timing is an issue insofar as there's a backlog because of the pandemic, and the processing time can now easily be a couple to weeks, even couple to months, and in some scenarios even more. Alternatively, you can fly in under your visa-free status and apply in Germany. Based on the assumption that we would grant those benefits to UK nationals also, like we did to our other best friends from Australia, Japan, and many more countries. But if you do that, you fly in and then have to deal with the local authorities that sometimes are even more busier. So generally, you're better off flying in before you have applied and secured a permit at home.
Thank you, Gunther. That's really helpful. So I think the key takeaways for me is, if the law firm is fully aware that there are going to be business meetings that would exceed the exemptions, and there is sufficient time, try and secure the work permit in advance of travel. If that's not possible, then you will have to then fly into Germany and apply for the work permit there. But as you say, it's just the practical consequences. It'll take longer to secure there than it would be had they secured it in advance of travel.
Yes, indeed. And in addition to that, if you know that a specific lawyer is likely to fly in to Germany and other countries, regardless of whether that is actually planned, I would not fly, I would apply for such a permit in advance and share the case in a way that I would say it's likely that he or she will be flying in on a frequent basis. It may be 2 times per month, it may be more, and we would like to get a permit for the whole year or even for a couple of years to have coverage for the full stretch.
Excellent, thank you. That was really helpful. Thank you again to Iain and to Gunther for taking part and sharing your knowledge and expertise. Thank you for everyone that has taken the time to listen to this broadcast. We hope that you found it really helpful. Please be on the lookout for our following recordings that we have on a few other countries in Europe that will be coming up soon. Thank you.